Today, we're explaining an immigration issue that made big waves in the news a few years ago and is about to make a big comeback with the new Trump administration. The public charge rule. If you're wondering what it is, how it works, and why we're talking about it now, stick around, because this issue could have huge implications for millions of people in the immigration system. Let's start with the basics. The public charge rule is part of U.S. immigration law, and it's been around in one form or another for over 140 years. It's essentially a test that immigration officials use to decide if someone applying for a visa or a green card is likely to become what's called a public charge. In other words, someone primarily dependent on government assistance. If they decide the answer is yes, your application could be denied. Now, for most of its history, the rule was pretty narrowly applied. The government mainly looked at whether an immigrant was relying on cash assistance, like temporary assistance for needy families, or long-term care at government expense. But, like many things in immigration law, the devil's in the details, and those details changed dramatically during the Trump administration. In 2019, the Trump administration expanded the public charge rule in ways that caught a lot of people off guard. Suddenly, it wasn't just about cash benefits anymore. They added things like Medicaid, SNAP benefits, also known as food stamps, and even housing assistance to the list of things that could count against you. And it wasn't just about what benefits you were using. It was also about what you might use in the future. Immigration officials started looking at things like your age, your health, your education, your job prospects, and even your credit score to decide if you might end up relying on public benefits someday. But that's not all. They also introduced a form called the I-944, or the Declaration of Self-Sufficiency. And let me tell you, that form was a nightmare. It was 18 pages long and asked for an incredible amount of information. You had to list your assets, your debts, your household income, your sponsor's income, even your English proficiency. Oh, and they also raised the income requirement for sponsors, making it much harder for families to bring their loved ones to the U.S. unless they were well off. It wasn't just paperwork, it was a roadblock, plain and simple. Now, this policy also had a massive chilling effect. People stopped applying for public benefits they were legally entitled to, things like food assistance or Medicaid for their kids, because they were afraid it might hurt their immigration case. Even if the benefits didn't count under the rule, the fear and confusion were enough to keep people away. Then came the Biden administration, which made rolling back the Trump-era public charge rule a priority. But here's the thing. Undoing policies like this isn't as simple as just signing an executive order. Courts blocked the administration from scrapping the rule right away, saying they needed to go through a formal rulemaking process. So that's what they did. The process took time, publishing proposed rules, taking public comments, analyzing the impact. But by 2022, the Biden administration had finalized new regulations that essentially restored the pre-2019 definition of public charge. That meant non-cash benefits like Medicaid and SNAP were no longer considered, and the infamous I-944 form was scrapped. For a while, it seemed like the public charge rule was back to being a more narrowly defined policy. But now, with President Trump returning to office after the 2024 election, it's likely we'll see this issue resurface, and not just in the same form as before. If history is any guide, we can expect a more aggressive approach, possibly even more expansive than what we saw in 2019. They could reintroduce stricter forms, raise the income requirements for sponsors again, and expand the definition of what counts as a public charge. So what does this mean? Well, here's where things get interesting, and where the clock starts ticking. First, it's important to understand that immigration regulations like the public charge rule don't change overnight. The Biden administration's rollback of the Trump-era rule taught us something critical. Changes to policies like these must go through the full regulatory process. That means public notice, a comment period, impact assessments, and more. This isn't just a bureaucratic box-checking exercise, it's a legal requirement. Courts have made it clear that any new administration, including Trump's, can't just wave a wand and impose sweeping new regulations without going through the proper steps. This gives us a crucial window of time. While new forms and requirements can't be implemented immediately, we know how this story tends to unfold. Once a new public charge rule is proposed, fear, uncertainty, and confusion start to ripple through immigrant communities. People will wonder, should I apply now, or will this hurt my case later? Will sponsors meet the new income thresholds? What if my health or age makes me a target under expanded criteria? These are the kinds of questions that keep families awake at night. But here's the good news. Immigration changes aren't retroactive. If you or your family are already in the system, if your application has been submitted and is pending, the rules that were in place when you filed are what apply to your case. That means acting sooner rather than later can shield you from the uncertainty of what might be coming down the line. This is particularly important for anyone applying for green cards or sponsoring a family member. You're working with a limited window of opportunity to submit applications under the current, more straightforward rules. The time pressure here isn't hypothetical, it's real. Once new regulations are formally proposed, they'll dominate the headlines and bring a surge of misinformation. People will panic, and backlogs in the system could get even worse. Immigration attorneys will be overwhelmed with clients trying to rush applications in before any new rules take effect. So, the best thing you can do now is stay proactive. If you're planning to file an application, start gathering your documents. If you're sponsoring a family member, double-check your financials and make sure everything's in order. This is also the time to ask questions. Reach out to immigration attorneys, advocacy organizations, or community groups to understand where you stand and what steps you should take. And if you're already in the process, keep up with deadlines and correspondence to make sure your case keeps moving. But let's step back and look at the bigger picture for a moment. Policies like the public charge rule don't just create legal barriers, they create psychological ones. The fear and confusion they generate can be just as damaging as the policies themselves. We've seen this before, and we're likely to see it again. That's why it's so important to approach this moment with clarity and determination. Educating yourself and acting now doesn't just help you, it helps cut through the panic that these changes can cause. So where does that leave us? Here's the bottom line: changes are coming. They may not arrive tomorrow, but they're on the horizon. The good news is you have time to act, but not forever. The next few months could be critical for anyone affected by the public charge rule, whether you're applying for a visa, adjusting your status, or supporting someone who is. Take advantage of the stability we have right now, because once the uncertainty kicks in, it's going to get a lot harder to navigate. Subscribe to our channel to stay informed as we keep following this issue, bringing you updates and actionable advice. But for now, if this applies to you or someone you know, don't wait. Start preparing. The more you can do today, the better your chances tomorrow.